More than 4 years after Dzhokhar Tsarnaev was sentenced to death for his role in the Boston Marathon bombings, today his attorneys asked the judge to throw out his conviction. They argued to a federal appeals court that Tsarnaev's right to a fair trial was violated when the judge refused to move proceedings out of Boston. In an 1,100-page brief, the attorney said, quote, almost everyone in the Boston metropolitan area had a friend or family member at the marathon, sheltered in place, participated in the manhunt, or bought or wore Boston Strong paraphernalia. This court should presume prejudice because constant, intense, and inflammatory pretrial publicity saturated all of eastern Massachusetts, so much so that more than two-thirds of the jury pool believed Tsarnaev was guilty before they heard a single witness. The attorneys pointed specifically to two jurors who failed to disclose a personal bias about the case, including the jury foreperson who had sheltered in place during the manhunt and called Tsarnaev on Twitter a piece of garbage. They also say the judge who oversaw the case, George O'Toole, failed their client by refusing to admit evidence about his older brother, Tamerlan Tsarnaev, who was killed in the manhunt and was later implicated in the 2011 triple murder in Waltham. But when I recently spoke with the lead prosecutor in the 2015 trial, former acting U.S. Attorney William Weinreb, he wasn't buying any of those arguments.
All of those arguments were made at the trial. There's nothing new here. This isn't like some new discovery that just came to light. The judge in the trial, who was a very fair judge, very good judge, considered these arguments and rejected them. I don't see anything new that's being said that would lead to a different outcome.
So, who's right? Joining me to discuss are Brian Kelly, former Assistant U.S. Attorney, and as I mentioned, the lead prosecutor responsible for putting James Whitey Bulger behind bars. He's now a partner at Nixon Peabody. Brian, it's good to see you.
Jim, how are you?
Renee Landers is a Suffolk professor and law school and constitutional law expert. Good to see you, too, Renee.
Thanks.
Let's go down the list if we can. I know venue changes are very rare, but if any case, like, for example, the Oklahoma City bombing, which wasn't tried there, but in Denver, if any case merited a venue change, was this not one, Brian?
No, I don't think so, because what they were asking for was to move it to Springfield, and Springfield's hardly in the middle of nowhere and didn't hear about this crime. A lot of high-profile cases are tried where they occur. So I think, you know, it's right to be careful and to make an inquiry, and that's what was done here.
I don't want to get overly legalistic here, but since this case was tried, there was a case also in the same appellate circuit out of Puerto Rico called the O.J. Simpson case of Puerto Rico, where there was a ruling by the appellate court that the failure to change the venue out of Puerto Rico was a mistake. That's pretty rare, too. Is that not going to guide this court to some degree?
No, I don't think it is, because in this very case, what's unusual is that pre-trial, the First Circuit said it did not have to be moved. And they cited that Puerto Rico case. And the difference in the Puerto Rico case, and it's a big difference, is that the defendant had just been tried in a separate case. There was lots of publicity, and that was what the court thought tainted the locale for the Puerto Rico case. And they said Puerto Rico, unlike Boston, is not exactly a large, diverse place. It's kind of an insular community, more prone to prejudice than a $5 million metropolitan area.
I want to get to your sense of the Puerto Rico case in a second. Before that, there's a popular misconception, I think, amongst the public that if you know anything about a case, then you can't participate in a jury. That's not the issue at all. The question is, can you impartially judge this defendant in this case? As I said, the changes of venue are really, really rare. Why should this case have been won, or should it have been won?
Well, because I think that it's a difference of degree here in this case as compared to some of the other cases that Brian has referenced. Here we have a whole city that was on lockdown. I live 4/10 of a mile from the boat where he was captured.
In Watertown.
In Watertown. And so and I thought after that day, I had friends writing me literally from all over the world saying, "Are you okay?" And I thought, I'll never have to explain to anyone where Watertown is again. And 6 months later, I'm in Washington, D.C., and at a big conference, and people say, "Where do you live?" And I say, "I live in Watertown, Massachusetts," and blank faces. And that really said to me that my original sense that the trial should be moved was correct, because the public and other parts of the country had moved on and were not. Could you
have served fairly on that jury?
No, I wouldn't. I wouldn't say that. I wouldn't say that I could, because I think the appearance would not be fair. And here, our justice system worries not only about the actual fairness, but about the appearance of fairness. And I think the appearance of fairness is not present here.
Move to what I think is a much tougher issue for the prosecution in this case, or the United States government. This this social media presence by two of the jurors, the foreman, again, or the foreperson, I don't know if it's a man or a woman, doing this thing that Tsarnaev is a piece of garbage, and 21 other tweets. Another juror going on Facebook and going back and forth with friends suggesting, do whatever you got to do, I'm paraphrasing, to get on the jury so you can convict this guy. To me, if there was ever a textbook definition of bias, it isn't like there was nobody else in the jury pool. Is this not a problem?
Well, first of all, it has nothing to do with being in Boston, right? That's a separate
issue. I agree,
issue.
it's a separate
because
issue.
To her point, people in D.C. would know about the Boston Marathon, might not know about Watertown. But
they didn't have personal experiences like almost all of us did. Right. But this is a separate issue.
Juror
and I think,
bias. Look, the second individual, the one whose friend is saying send him to jail, well, that's not a big deal. That's what the defense lawyers wanted. Remember, in this case, it was really more of a prolonged sentencing hearing than a trial.
Because they admitted
their guilt.
Right.
So
right.
The real problem is going to be the first juror, the one who said, yeah, he's a piece of garbage.
How about that?
But, well, listen, it's colorful language, but I think any objective juror is going to think somebody who admits to being involved in a crime like this could be deemed a piece of garbage. That doesn't mean they have to be executed. And that's separate. And I think the verdict here says the jury was discerning. There's 30 counts he was convicted of. They only sentenced him to death on 6. Now, you put that trial in Texas, Alabama, I bet you get 30 counts of death penalty.
You buying that one?
No, I'm not, because I think, again, it's the appearance issue, that we really we wanted to run a trial that really seems to be beyond reproach. And when you have a juror who's done things like that on social media, who has tweeted things like that, then I think that you cannot make that argument.
Why do you say it's only appearance? I mean, again, I would argue with both of you.
Well, I
would say it's to me. Give me an example of more bias than you can ever show.
Can I just say one more thing?
Can
I just say one more thing about that? It's that it's fine to develop the opinion that he's a quote-unquote piece of garbage during the trial when you've heard the evidence that the prosecution brings against him. It is not fine, based on what you read in the media, to develop that opinion and then come and sit in judgment on the person at the trial. That's right.
Well, again, the distinction that they may make is he admitted his guilt. This is really just a sentencing hearing where under the death penalty statute they have to decide different mitigating or aggravating factors which warrant or may not warrant death.
So why wouldn't these show bias in that consideration?
Well, it doesn't disqualify the person. Clearly the person is not approving of this guy who's just admitted being in this heinous crime. That doesn't mean they also want him executed.
You're a defense attorney now. Would you let that person on a jury if you had a peremptory challenge for cause or?
No, I'd strike him, of course.
You would strike him,
yeah, but that's separate. That's separate.
Okay, fine. I got to move. Because there's a third issue here. The third issue, which I think is a strong one too, maybe not as strong as the juror issue, is the decision by Judge O'Toole to not allow evidence to be brought in about the alleged involvement of Tamerlan Tsarnaev in the triple murder that we all remember in Waltham. The argument by the defense lawyers being that if the jury had known that Tamerlan was responsible, likely responsible for that triple murder along with this guy, Todashev, it would be easier to convince them that he was the mastermind. Our guy was the second-tier guy who was led around by the nose. I mean, my words, not his, not theirs, and make it less likely he'd get the death penalty. How strong is that one?
Well, I think that's a weaker argument, a somewhat weaker argument, because these evidentiary rulings about evidence of guilt in another crime are, kind of very sketchy. Although the burden is different in the sentencing phase, and that perhaps the judges should be a little bit more lenient in letting this sort of information in. I just think that why should the prosecutor? Why should we have that be a filter on what the jury hears about that? Because if the defense attorneys can make something of it, that so be it.
I don't understand why the judge in this case. I understand you're going to let prejudicial stuff in or stuff that's going to be exposed. This wasn't even about Dzhokhar Tsarnaev. It was about his brother. So why wouldn't he let it in?
Because it's irrelevant. I mean, the issue is whatever this defendant did it warrant the death penalty? He admitted he did it. And, it's kind of a stretch to say, he's brainwashed or something by his brothers. There's lots of crimes that are terrible crimes where not just the ringleader deserves to be executed according to juries. So I don't think it would have mattered at all.
If you were arguing this appeal...
But we don't know because we didn't let the evidence
in. That's a good point. If you were arguing this case, would you argue, is it even relevant for an appellate court to hear that the community shouldn't have to live through this kind of pain, again, of a trial, or is that not relevant at all?
I'm not sure that's terribly relevant, honestly. I think the bigger point is, Judge O'Toole is, in fact, a very experienced trial judge. The inquiry he did can always be second-guessed, and that's what these appeals are in these death penalty cases. They're second-guessing, nitpicking everything to get the person off death row.
What's going to happen here?
Well, that's a tough call because it was 2-1 originally that it shouldn't have been kicked out of Boston. I think they keep that position. They'll be very troubled by that statement that he's a piece of garbage by one of the jurors. But ultimately, given the fact the jury did not recommend death on all 30 counts, I think that will show them that they were able to put aside any biases
uphold the whole thing.
And uphold it.
How about you, quickly?
I think that that I agree that they'll probably uphold it, but I think it's the wrong decision because I think it sends the wrong signal about how the process needs to be fair, not only in fact, but also in appearance.
And we should say, by the way, even if they were to rule, it doesn't necessarily mean a new trial. It might be that the prosecutors agree to let him plead guilty in return for which he'd get life.
Well, the appeals court would be ordering a new trial, then the government would make a decision.
Right.
And my prediction is that they would try it again.
And the standard is different this time around. I think it's easier for the defense lawyers to make the argument because it's very hard before the trial when you have this appellate remedy for the court to come in and order the trial judge to take a particular action.
Renee, it's good to see you, Brian.
Good to see you, too.
Thanks so much for your time. Appreciate it.
Take
Renee
care.
Landers, Brian Kelly.